welcome to 2022. And in our 262nd session today, we have a wonderful speaker, Radhakrishna Murthy. We should be especially thanking him because it is in fact he who introduced this wonderful speaker to this platform. And I'm indebted to Vijay also for being instrumental in having this wonderful speaker today. And in this new year, let us start this new session of Letils with a topic which is very, very important for everybody in the sense like how to, what to, I mean, the discussions we were having earlier, what to say, what not to say, and things like that. I think every advocate or an advocate aspirant would be benefited by today's session. Senior Advocate Ravichander sir, namaste and welcome to our platform. And we are privileged by the presence of Justice Ramkumar sir, Justice Ramakrishnan sir, Justice Kondaram sir, Justice Hariprasad sir, and all of you wonderful participants. And on this first day of this new year, let us go straight on to the introductory remarks by Justice Hariprasad sir. Over to you, sir.
Thank you, Shyam. Very happy new year to all my esteemed brothers and dear friends. I was just wondering why Shyam has selected these two topics together. Actually, each topic probably can have one session, because every aspect involved in these two topics are very important so far as a lawyer is concerned. Anyway, maybe because of the fact that a speaker like Shri L. Ravichander is available today, that's why he must have selected this topic, combined these two topics together. Anyway, that's good. Let us begin a new year with a very, very, very useful session for the legal fraternity. Now, my esteemed brothers, Mr. Justice B. Ramkumar, Justice Kodanraman, Justice Ramakrishnan, and dear friends, Vijay, Mr. Ravu, Mr. Dilip, Dr. Srikanth, Parthasarathi, everyone who have joined the platform are very competent persons in their own field. So they also can contribute to this topic after Shri Ravichander has introduced, or rather make an address in this subject. No, actually, the Advocates Act, if you go by these two topics, communication skills and good practices for lawyers are two sides of one coin. And according to my view, of course, subject to the views expressed by the learned speaker and other persons, other erudite persons here in the platform, according to me, the Advocates Act, especially the Bar Council of India rules, which part 6 deals with the governing the advocates and the standards of professional conduct and etiquette. So those are areas where you find some standardization of the behavior and conduct of lawyers. And see, in Rule 36 of the Bar Council rules dealing with the conduct of the lawyers, there is one classic decision by Justice V.R. Krishnaiyer. I'm sure everybody will be aware of that, but still I'm referring to that decision, that is Bar Council of Maharashtra versus M.V. Dhabolkar, a year 1976 Supreme Court 242, authored by Justice V.R. Krishnaiyer, where his lordship said that, I'll just read out one, that is my introductory speech actually. Krishnaiyer, in his inimitable style, says, Rule 36 fairly construed sets out wholesome rules of professional conduct, although the canons of ethics existed even prior to Rule 36. Rule 36 is not the only nidus of professional ethics. The canons of ethics and propriety for the legal profession totally taboo conduct by way of soliciting, advertising, scrambling, and other obnoxious practices, subtle of clumsy, for betterment of legal business. Law is no trade, breeds no merchandise, and so the commercial competition or procurement should not vulgarize the legal profession. That is the language used by Justice Krishnaiyer in this decision. So this is the area probably I'm sure learned speaker will be bestowing his attention regarding the ethical aspects of the legal profession. And regarding the communication skills, what strikes my mind is that, of course, language, good command over language, this diction, these are all a very, very this plus point for a lawyer is concerned. Apart from that, a lawyer must have clarity of expression. He must be what you call bold enough to put forward his points, though firmly, though politely. And these are all these skills, skills of advocacy with reference to the language that has to be exhibited in court. I'm sure in this session, we will hear learned speaker Sri Ravichander about all these aspects. And with these few words of introduction, I hand over, I request Mr. Shyam to begin the session.
Thank you. Thank you. This is Hariprasad, sir. When we have an introductory remark on the subject, let us have an introduction of the speaker as well. Vijay is with us today for that. Vijay, over to you.
Thank you. Thank you, Shyam. First of all, Happy New Year to you all.
Happy New Year.
Hope we have a brighter year than what we had in the last couple of years. Ravichander has been known to us for a very long time, and he's a designated senior counsel since about, he was designated sometime in 2010, and he practices on all branches of law. To start with, he's one of those unique counsels who has got a lot of interest in various aspects, like cooking. He does a lot of anchoring, conducts debates with children, still very enthusiastic of it because I see that quite often. And he gives film reviews from time to time. In fact, every film review I see, be it in print journal or in YouTube, you can find Mr. Ravichander giving his reviews about the films which have released. Cooking, he has his own cooking channel, which I have subscribed to. And I mean, that only shows his passion towards various other aspects of life, not only just law. One thing about him is he always walks the talk. Whenever he takes a stand, I've seen him in issues regarding the bar. He has always stood up and he always walked the talk, which is a very rare breed that we see here. That's about him. That's about his character. Connoisseur of Carnatic music. And one standout thing is that there is this Golu. There is Golu, which is arranged in the month of... Am I audible?
Yes, yes, yes.
Yes.
There is this Golu, which is arranged in the month of Dasara, where his entire house, his independent house, is converted into a Golu. From the ground floor. Each and every room up there is converted into Golu, Bommal Kolu as we call it in Telugu. And he has toys right from his grandparents' time. That's what I was told whenever I visit them. And they are neatly stocked up after this Dasara. And this amazing energy that he has in arranging this Bommal Kolu, Golu in the entire house. I mean, if there is a video, I think it is available. It should be available in YouTube. You can understand the size of the Golu. Entire first floor, every room with what you call
Dogmas.
yes, with a particular idea. Each area is arranged with a particular mindset. Like, you know, for Vishnu, you have everything related to Vishnu. You have Lord Shiva, everything related to Lord Shiva. And I don't think you will find more number of Ganeshas than you find at his house during that particular time. I think it will be, sir should tell me, it should be at least around 200-300 Ganeshas. Ganeshas playing cricket, playing chess, playing whatever, everything possible, playing Carnatic music. Beautiful
assembly.
Crafts, assembly. So, and to talk about this particular topic with regard to communication skills, and I think there's no better person than Mr. Ravichander, sir. And he has always helped us whenever we have asked him. So we got great regard for Mr. Ravichander. Thank you, sir. And over to you, Shyam.
Thank you, Vijay. It's wonderful. I think Ravichander sir has got two avid fans among us. I mean, one is Ramkumar sir. Once he mentioned about Carnatic music, I saw the face lighting up by Ramkumar sir. And when somebody was talking about your gastronomical adventures, or rather food, I think Ramosan sir would be with you. I mean, we always try to put his luck saying about food. Like, I mean, today is a wonderful day in the sense like first day of 2022. What a treat we have. I mean, the different, the kind of things that has been served today will be, I'm sure that it's going to be wonderful. Over to you, sir.
Thank you very much, Shyam. A warm evening to all dignitaries and friends here. My toughest task, obviously, will be to live up to expectations and those grand intros given to me. Justice Hariprasad quoted, and I was to begin with that any which way. Law is no merchandise, Justice Iyer. But then, law is about selling ideas. Law is about selling stories. Law is about a human saga being converted into, being reduced sometimes to semantics and sometimes to a philosophy. But always threaded between this is a simple story of human suffering. How do we translate this? How do we embellish this with law, with fact, with logic, with whatever you want, is how finally a lawyer leaves an impression before a judge. We must understand that finally the job of a lawyer is to sell an idea, is to sell a certain set of facts in whichever branch of law he may be. He may be dealing with commercial law, he may be dealing with criminal law, he may be dealing with civil law, constitution law, or you name it. I see PVS Giridhar, so you may be doing administrative law. So it all depends on what branch of law, but the fact remains is that you are selling a narrative. And I also see an amazing number of people from Kerala. And it's very intriguing for me as a cinema critic to understand that lots of people in India suddenly realized that good cinema gets made only in two parts of this country, West Bengal and Kerala. West Bengal, of course, is well spoken of. You've heard of Ritik Ghatak, you've heard of Ray, you've heard of Rituparna Ghosh. But Kerala, we haven't heard as much. We all, you know, as youngsters, sometime or the other, heard from a distance a Mammootty, a Prem Nazir, a Mohanlal. But today, an entire new generation has made such compelling viewing on OTT that communication skill, even to the simplest of ideas, seems to have become a Kerala monopoly or a Kerala prerogative. I think if we begin to see their cinema, we will understand how important is it to understand that communication is not only about content, it is about how you present. You could have the best of knowledge. We had a lawyer in our state, we have a lawyer whose knowledge of law is so amazing. He's read every statute by the back of his hand. I think there's no judgment which is written or pronounced that he's not aware of. But he once in excitement told the judge that instead of saying that the judgment has been quashed, he said the Supreme Court has been quashed. So his entire effort turned into a joke. Now that is why I'm saying we need to understand that language and presentation of a case in a court of law is often in our system not given the primordial place. It psychologically occupies in the minds of men, namely clients and judges. And many of us have made a habit of bringing it to the back burner because it's not one of our saleable virtues. Not because it's unimportant, but because it's not one of our saleable virtues. And in our profession, nothing exceeds like success. There are three important factors. Almost before I go directly to delve on the matter, I must say that I did two mistakes before I started this entire session. One is I had no clue that I was speaking to a whole set of veterans whom I should have been listening to rather than addressing. Excuse me that, because when I was approached so hesitatingly, I somehow got it in my mind that I was speaking to a whole set of just raw, behind green in their ears, lawyers. I didn't know I was speaking to such people who were going to make me blush with embarrassment. I didn't know there was Ram Kumar here, barrister here, Justice Kodanda was here, etc., etc. But that notwithstanding, I'd rather go with my text, go with what I basically thought of saying. Therefore, excuse me if I sound very platitudinal or if I sound like I'm giving you a sermon. That was not the idea. I only thought I'd share my experience with youngsters, which is not what I see on the picture screen. But then what I plan to say is look at this more as a personal experience rather than as some kind of a vertical coming from somebody who knows it all and is giving it to somebody who doesn't. Please. I also forgot to ask, and I plead guilty, of the profile of my audience. I presumed when I threw up this subject that it's for a younger, for audience that was yearning to become advocates, not ones who have gone past that stage and who are brilliantly successful lawyers in their own careers. So excuse me, these two. I believe that there are three facets to a good lawyer speaker. I've noticed very strangely, there's a public belief that if you are a lawyer, you're a very good speaker. And I can tell you, 12 out of 10 lawyers make bad speakers. Because I think the adrenaline comes only when they see the carrot. And while you're a speaker, the adrenaline is the mic and the podium. Now, with these two lying there and the most important carrot that they are used to not being there, it doesn't gel for them. So the public perception that all lawyers are good speakers must go, must stand shattered. What makes a good lawyer speaker? A lawyer speaker is one who does not speak too much, but is familiar enough to tell the listener, whoever he may be, that he's not just a lawyer and that he's carrying out a human saga from the stance of experience to the stance of somebody who's going to be judgmental. Three very important broad spheres, I may say. One is your matter, one is your language, and third, of course, is your presentation. When it comes to matter, again, I see there are three basic areas of matter. One is the law governing the subject. Nowadays, law keeps changing. You know, when we became lawyers, we had 40 amendments to the Constitution. Now you have 100 amendments to the Constitution. So in a span of about 30, 40 years of our experience as lawyers, we've seen arithmetically 2 amendments to the Constitution every year. So just imagine how much of change there are in all branches of law. The increasing tribunalization of the Indian justice system has also led to a variety of laws where the biosphere of those statutes are not exactly the same, or they do not fall in perfect juxtaposition with constitutional diktats. And unfortunately, and I'm saying this with a great sense of responsibility, unfortunately, when these statutes are tested, they are tested by some very old tools of is it in violation of the Constitution? Is it in violation of statutory power of legislative competence? That's about all and nothing else. The contemporary intent and original content theory is not applied. Various other tests that sociologically required to come in are not applied. But nonetheless, there are so many laws marching alongside every person who moves from home to court or from college to court. Why, even as I'm talking to you about an hour ago, a friend, somebody called up and said, he's a Muslim, he has a daughter who's to get married. They had planned the marriage 6 or 8 months from now, she's 18. So they say, sir, what do we do? Can we get her married now itself? Or should I wait till the law comes? Or what do we do? So law is so fastly changing that we need to know all the laws governing the subject. The second, of course, apart from the law, is the case law on the subject, because that's another huge area. But today's community of lawyers have greater advantages of getting there than many of us did during our times. We belong to a generation, I'm sure Khudanda will agree with me, we belong to a generation when we had to sit in an office till late in the night, pull out the quinquennial digest and keep looking up and down, up and down, up and down for words and phrases and various other crude skill sets of getting to judgments of importance. And that is why you would realize in many years in the 60s and in the 70s, a lot of judgments would come contradictory to one another because the homework of the lawyer was not as perfect as it is today. It is perfect today for two reasons. One, today's lawyer is far more sharp, focused, skill-setted, prepared than I was. Second, state of the art. You have legal search engines which are far more sharpened, razor edge, and therefore your research time is reasonably saved. So law, case law, these are two very important aspects of matter. And when it comes to subject matter of a case, I would say there are three things that a person needs to know when facts of his case. One, what he needs to tell the court or put in his drafting. Two, what he needs to avoid saying. And thirdly, what is the facts that his opponent knows and would any which way state if whether you state it or not. These are three aspects of factual pleadings that every lawyer must engage in at every stage of a case, when he's drafting a case, when he's responding in a draft to a case, or when he's arguing a case. These are largely aspects of matter. Also about case law, I've told a few advocates general in my times, please understand, unlike other lawyers, principal law officers are friends of the court. They are constitutional amicus. They need to expand the debate. They need to get to an expanse of the metaphysics of law and not deal with just a statute that is before them. That's their job. I've said this again and again to some intellectual judges and to a few lawyer judges, a few lawyer friends. If you can, look at law elsewhere in the world. For example, we take a very typical example, the surface in India. If you look at lawyers and judges in India, they seem to believe that the purpose of that law is to ensure that banks and others get back their money. While in other Western jurisprudential, commercially successful countries, the paradigm is to see how can we ensure that the industry does not die and at the same time that the public finance is not exploited. Now, this subtlety of understanding the purport of the socio-economics of that legislation is something lost to the wordsmiths of our times, because we get stuck in 140-page judgments where 85 pages is writing down what this judgment said, what judgment said, or quoting profusely from the statute itself. Therefore, today, a word to share with youngsters is, if you can, please look for judgments and similarities from countries, at least Commonwealth and American, because these still leave an impact with our judges. Nothing that is absent in the pleadings must be stated. I always say, and I've said this in courts too, that a single sentence that is not pleaded and stated in a court hall amounts to gossip. And the last place you should be doing it is in a court of law, unless you're sitting on the bench. Law, as I said, is today dynamic. Sometimes it's also counterproductive in sense there are certain branches of law where the government wants to give certain things, which while in other branches of law, it takes away. So even these contradictions are things that function at a larger orbital space. We need to understand them while we prepare ourselves before a court of law. The next thing would be language. Now, I'll deal with language and presentation almost they intertwine once in a way. You'll excuse me for the very what do I say? It's not properly classified. It's not classified enough. For language, I'd say please make simple sentences. I hope I'm walking my dog. I hope I've not used very big words in whatever I've said. I hope I've made single sentences, small sentences, though I did see Kodanda go off for a sleep for a small minute or two. I just thought it must have been an old judicial habit. Avoid complex sentences, especially when you're arguing. Understand that the focus time of any listener is very short. He's not following your trail. He's taking you sentence by sentence. So make them small. Somebody over here whose reference to Carnatic music, why did GNB become that great singer that he was? Why was he that paradigm shift? Because his Neraval and his Swaras were short. He didn't make the long Neravals and long Swaras. They were very small. Therefore, he became the brisk singer. Therefore, short sentences make larger impact. While drafting and while addressing the court, ensure that you must avoid both repetition and, as I said, long sentences. Ensure your grammar is in place. Now, this is easier for this generation than it was for us because you have a software that when you're writing your drafts, you realize that there are grammatical errors that creep in, and the software tells you there are, I think, Word and all of them tell you that there are grammatical errors. They caution you both with spell and with grammar. With spell, obviously, most of us by default have an American dictionary there. Every time you open a file, please say English dictionary and go to it. Otherwise, you will have spell errors. And in your drafting, please only plead facts, not the law. Justice Kodanda will again bail me out on this. We had one of our greatest lawyers of our times, an expert on constitutional law, whose affidavit would be 3 to 4 pages, Justice P.A. Chowdhury, 4-page affidavits. He'd say, these are my facts, that's all. Law, you'll only cite the proposition that you want to say. You'll say it's in violation of this provision. You don't have to write out the provision. You're not a law publication. Your affidavit is not a law publication. Just cite the provision of law. Do not detail it. You'll say it is in violation because of whatever reason you have to. When you're with a client, this is something I have learned, again with somebody connected with Kerala, your former Chief Justice, Justice M. Jagannath Rao, who is also a judge with our court and went on to becoming a judge of the Apex Court. In one of the very early lectures when I was a very young lawyer, he told me, and that is a practice I've now followed at least for 30 odd years, and it has stood me in good stead. And I'm sure some of you who have seen me practice in court see me carrying a book with me every time I'm arguing a case. What I do is, there's a very simple technique. It doesn't call for, it's not a rocket science. I write down whatever the client is telling me, and then I take about 5 minutes to put them chronologically on my rough sheet of paper. And then I dictate, those days when I used to dictate, I would dictate it chronologically. Now, when I write them down chronologically, and I use a red pen whenever a date comes into my writing. So that what happens is two things happen. You don't jumble up your facts, one now, one past, one present, one future. This is not a Gulzar film where, you know, you can go to the past, then come back into the present, then again go back into the past. This doesn't happen. Your narrative has a linear function. Therefore, ensure that your narrative on paper with you is present chronologically. Translate that into your narrative in your pleading and ensure that you stick to your pleadings in the course of your oral arguments. Presentation. Now, this is the big challenge. How I wish I knew it. It's, you know, good presentation in a court is like a successful film. After making a film with all his passion, Mera Naam Joker, Raj Kapoor flopped. And then he made a cross film, Bobby, and he made the biggest moolah of his life in the movie. Therefore, there is no formula for writing, for a presentation in a court of law. There is no the way of doing it. But there are some standard ways. You know, again, while I apply this even to good public speaking. For example, the two greatest speakers I've heard in my lifetime, the political arena of this country, are as different as chocolates from cheese. Pandit Jawaharlal Nehru at one end and Atal Bihari Vajpayee at the other. Two brilliant orators. One who spoke like an intellectual, one who spoke with passion, one who spoke in stylized English, one who spoke with passionate Hindi. So you must give a context to your style. You must understand who your audience is. If a judge is a judge who loves the law, please don't talk fact. If he's a judge who's a common sense lawyer, throw the lawyer, tell me what you want, tell him what he wants. Please adjust yourself. Please first, I would say, if you go to a new court hall, or if you're not aware of the dynamics of the judges, go to that court hall 15 minutes, 20 minutes before. When I do this, when I go to another state, luckily, Kodanda's been my pole star. He's been my guiding factor. I've said, if you are a designated senior, you must at least appear in 4 or 5 courts in the country. And I've been fortunate to be engaged in other courts. So when I go there, what I do is I sit in that court hall half an hour before my matter reaches to see what kind of a judge is he. What is it that is going to work with this man? Is it just my book? Or am I playing with his psyche too? And please understand, lawyers are constantly playing with the psyche of a judge. Whoever he may be, whatever hard nut he may be, he's a human being. There are areas where you can appeal to him, but do not play games. They are smart. They've seen enough and more than like me and you, years on end. They know how to make the truth from the farce. So be genuine, but do your homework on what kind of a judge you are addressing. horses for courses always held. If you believe that you are before a judge who doesn't like too much of glamour, get simple. If you think you'll have a judge who likes you to be the stiff upper lip kind, somebody like Shrikant Parthasarathy, then ensure that you have it done that way. Address a judge once, maybe twice. If you're arguing for a long time, maybe a few times. Addressing a judge with your lordship, your ladyship, your honor is not a space filler. We keep repeatedly doing it whenever we are fighting for words. Let's give it up. And I'm going to tell you how I fought fighting for words. We all fight for words. But there is a process, and if we can train ourselves in it, it's not unattainable. Write down your case in a book. My mother told me when I was a child of 8 years, which was roughly 60 years ago, that 10 times reading is 1 time writing. To this date, I write down my presentation before a court. To this date, after I read the latest AR, I write down the head note in a book and then give it to my colleagues to classify them into the chapters, into the parent. This is a good practice. To those of you who are brilliant or those who look down on these methodical methods, so be it. But for me, I'm only telling you from my experience what has worked for me. You can quote, but keep it to a minimum. Don't quote too much. I have a friend of mine who quotes too much of Shakespeare in court. So he's called the Shakespeare Wala in my court, at least in the corridors. Don't do that too much. Because also you must understand that many judges are not as familiar with literature. So somewhere they feel offended. And that's not what you want, right? You're not going to go to, I can only recall this small example of a guy who goes to a county house and taps the door. And even as the lady of the house is trying to tell him, he just shuts her off and continues, says, please get me these. They're sitting on a nice, good carpet. He says, first get me a lot of eggs from the house. He breaks them on the carpet. She's about to say something. He says, just keep quiet. Then he says, get me tomatoes, get me this, get me that. Multiple things, and throws and mucks up her carpet and tells her, now see how my carpet cleaner is going to work. Then she tells her, now will you let me speak? I don't have electricity. So ensure you don't play on what they don't have. That's a bad bet. So sometimes it gives you a nice, it helps build your own confidence to quote somebody, to make it familiar, but don't sound that, sometimes it looks very put on, don't do that. Then understand a good speaker and a good lawyer is one who's listening more than he is speaking. I knew a lawyer in Hyderabad who went on to occupy the position of an advocate general. He told me once, Ravi, don't be worried about your case. Don't be worried. Government will file its counter. It will have enough loopholes. You just build a skeleton. They'll give you the flesh of their weaknesses. You can dissect the daylights out of it. So important, please listen to the other side. Like after all, what's a law case? It's a debate. And in a debate, it's not what you're selling. If you can puncture what the other guy is selling, and the judge has to buy one of the two products, he's by default buying your. Therefore, pay more attention. In the court. Yeah. Therefore, follow what the other person is saying. And it doesn't call for too much ears. It just calls for trained ears. Like I was talking to you just when Justice Radhakrishnan was telling somebody to take some files and keep it somewhere. And I paused. This is all that we need to do. Keep your eyes and ears open constantly, and you will know how easy the job is. Maintain dignity in the court. This is a very important thing. No person will take you seriously if you're very submissive or if you're very arrogant. You need to walk this tightrope with an ideal balance. At least, you know, Kodanda may say, Ravi, you know all this and still you make a fool of yourself in a court of law. I don't know. I know all this. As Vijay said, I'm trying to walk my talk. I may be making my mistakes, but I can only say I make this effort consciously. I try to be dignified. I try not to be apologetic. At the same time, I try not to be arrogant with the court of law. Avoid casual expressions like yay, nay, ASAP. Oh, these are new words that we are using for the except a freak off or a whatever equivalent of that. We seem to be using all colloquial expressions in court. This is a no-no. I'm not being stiff upper lip barrister, but I'm only telling you that a professional carries a certain lingua commitment, and it reflects on how familiar you are with the verbiage of the profession, or how you are not if you start using familiar words into your professional communication. Don't get personal with the other side. Never get personal with the other side. He's as bad or good a salesperson as you are. He has a cause, you have a cause. Don't lose your cool, especially when the other side is losing it. This is Ram Subramaniam one day. You know, while I'm telling you all this, it's easy for me to tell you, I'm a guy who does lose his cool once in a way, probably because I carry a little kind of passion in my style of argument. And I do put up a kind of false anger sometimes. And in one matrimonial matter, when I was trying to put up one of those false facades of anger, this is Ram Subramaniam told me, Ravichander, nowadays, more than the parties in a matrimonial matter, the lawyers are getting heated up. So that was a very subtle warning. And not many people have the same subtlety as Justice Ram has. So I would always tell people, keep your calm. Tell yourself that this is just a cause. And ever since that, at least now for 3.5 years, I've ensured that I don't lose my cool. I smile it off and ensure that we don't lose our cool when a matter is being argued. Follow the judge. This is a golden rule. He is your customer. He is the ultimate guy who's going to buy or reject your product. If he's asking you a question, don't tell him I'll come back to it later. Don't tell him I have a script, you'll have to wait for the whole film. Cinema abhi baki hai will not work with him. Answer his question and then go back to your narrative. Follow him. See how is he reacting. His body language will tell you where he is. You don't have to be an expert lip reader. Even a crude lip reader will tell you what is he telling the brother judge. Is the brother judge trying to help you, or is the brother judge trying to take you away? If you think that there is something of that kind, address the issue without addressing the name. These are subtle things that will come to you if you are otherwise prepared on the fact and law of the matter. Otherwise, you're so preoccupied with your fact, so preoccupied with your matter, that you may not have the time to know these nitty-gritties. Do not lose your court for your case. Doesn't matter if you lose a case with even very high stakes. If you have the judge on your side, another case with higher stakes, there's a chance of it coming to you. But you've lost a judge. Even cases with lower stakes, you've lost. We live in a highly, in a system where a lot is based on the pleasure theory of the judge. Like it or leave it, but that's the way it functions. I'm a hardcore lawyer telling you this. If anybody tells you, no, if law's on your side, why should you do this? Why should you do this? Is a theoretician. He's talking to you from the laboratory of law, not from the corridors of a court. I'm not saying please the judge by doing a namaste to him, saying, hi, sir, how is sir? Walk up to him whenever you get a chance at a party and bore the daylights out of him and tell him he's, oh, Daniel, come to judgment. Don't do all that. They can see the fake in a mile. But do not lose a judge, because at the same time, do not allow a judge to bully you. That is unacceptable. We had a genius judge who would bully everybody at the bar. I was very lucky. She never tried it on me. And I was lucky for the short span she was here. She never ever bullied me. I think there's something in us where we are very clear about what we are saying, what we are doing, that the judge finds it not necessary to bully us because they know that we are not here on an ego trip with them. And we are not here to win brownie points for our biodata. I'm not writing my autobiography on the basis of what I've done in my legal profession. Therefore, stand straight, stand erect, but don't stand with the libido. Dress properly. They're very important. We have inherited an Anglo-Saxon system where appearances do make a difference. And when I say dress properly, I don't mean dress flashily. I don't say wear a tuxedo. I'm not saying wear designer coats. All that I'm saying is don't come to court with jeans. Don't have your shirt untucked. Don't wear jazzy pants. It's not difficult to buy a white pant and a black pant and wear them to court. Don't wear stripes and polka dot pants. Very tight clothing, no in our court halls. Slippers in courts, please avoid. And all of these apply to ladies too. I know I may be moving into territory which is nowadays seen as politically incorrect. But I'm an old hag. I'm not, these are not sexist statements. I'm saying it asexually. Please don't wear too tight clothes. Now, I don't have any anatomical references to this. I'm only saying you need to breathe freely in a court and therefore be pleasant. I'm also saying don't dress jazzily. I'm not saying don't apply lipstick, but you can't wear dark maroon or pink lipstick and come to court. What will you wear if you go out for a party then if you're wearing this? Yeah, keep that nice lipstick from Lakme or L'Oreal for the evening, not for the morning. I like people who defy the code. Do not defy the dress code in the court hall. That's all I'm saying. I'm not saying I have a right on what you wear, but I'm only saying in a court hall, in a professional world, dress up professionally. And this has nothing to do with one sex. I'm referring to all the three sexes that I know of. Language, how do I, it's so easy saying improve your language. What do you do? How do I improve my language? One is read. I remember very early in my career, one very senior lawyer told me, why are you reading things other than law? It is something I have studiously followed by defying his guidance or advice. I read. I know Kodanda reads profusely things other than law. He's gifted me books other than law. He's never gifted me a law book. So we need to understand that reading is a habit we need to inculcate. Fortunately or unfortunately today, that habit is dying. I don't want to sound like one of those grand old guys who read a lot and today doesn't know. I know what Saul Bellow said. He said, every generation thinks it is at its nerve's end. And the worst is yet to follow. No, I'm not saying that. I know of people of today's generation who are so brilliant that they make me feel embarrassed and shamed. But a lot of youngsters don't read. Please get into the habit of reading. Read law. It's very important. That's your bread and butter. But read law doesn't mean you read a statute and read only judgments. Please take the trouble of reading the journal section of the law book. It will give you insights which the judge may have missed and you may propound. Read philosophy, read sociology, because without that, law is an empty document. Read, and for many of us who still are not familiar with the language, yes, read biographies. Read biographies of different kinds of people, because life is all about experiences coming from various angles, not necessarily those in black robes. But read black robes also, because one of the best, two of the best biographies I've read are both people connected with law. One is Roses in December by M.C. Chagla, and one is Clarence Darrow, the great American novelist's biography written by two different people. You must read them. A lawyer's life is incomplete, according to me, if he's not read one biography at least of Clarence Darrow. Read newspapers, general books and biographies. And if you feel that you still are unfamiliar with the language, please make it a habit to take a newspaper or a book for 10 minutes, even if it is in your washroom, close the door and read it loudly. What happens after that is your tongue gets acclimatized to the verbiage, to the words that come but rarely to us in our regular conversation. So they have a natural bottleneck until we get used to it. Like, you know, I didn't know many speed breakers in Vijay. Now I know, because I've traveled on that road so many times. And yahan pe speed breaker aayega, yahan pe camera aayega. So when I reach those places, I tell myself, oh, I need to slow down or I need to be careful. So familiarity. So familiarity, ensure that you read till you get familiar with the language. Read regularly. Also listen to some good English channel from India, because they have a diction. Because I know people in Kerala have amazing English, but they leave behind a tell-a-tale accent, which they can do well without, because they're so brilliant otherwise. The answer to this is begin to think in English. How do you think in English? Start conversing with people, with your family, with your friends. But after your second round, don't go into a vernacular, continue to speak in English. Or sometimes people think it's better to go into English only after the second round, not necessarily. You can begin with it too. And to know this language is even more important today, because as Dr. Shrikant was telling us at the beginning of this, today, the world is seeing you in live streaming. The whole world is not only seeing you, you're often being, you know, for example, if I was in a court of law, I would have just said what I wanted to and come out. And I would have said it's my word versus what the judge said. Today, it's not so. There's a backup plan somewhere. I can pull it out. And you can show me, Ravi, these are as many grammatical errors as you have made. These are as many pompous statements you have made. These are so pulpitous as you sounded. So I need to be very careful with my language, with what I say and how I say, because we are moving into a different, wholly different physics of communication. Understand that? Now, I took all this much of time to speak about language, about court presentations. And the reason is I completely decided to do away with the second limb, thanks largely to Justice who told us at the very beginning how the Bar Council rules have enough. Justice Hariprasad told us how the rules present what are the best standards of behavior. What am I going to do? Repeat them for you? Instead, take it from the horse's pen, read it yourself, follow it. That's enough for good practices. Except that, two things from practice I would tell you that will gain you a lot of goodwill in court is, please learn to be courteous to your colleagues at the bar. Please learn to step back when they are charging. Said about Disarray and Glasgow that they were caught on a road where only one could pass. One of them said, I don't give way to fools. The other just moved back and says, I do. Follow that practice and it will help us developing a reputation. And if your reputation enters the court hall a few minutes before you do, at least 20 out of the 90 points that you have to win, you have won without effort that morning. On that count, I know where to shut up. I think I've reached it. I'll throw the house. I'll withdraw and leave the house to what has to happen next. But before doing that, thank you for giving me this wonderful opportunity. I'm really, really, really sorry that most of this was engineered to a completely green behind the ear audience. I didn't know I was speaking to experts. Excuse me this indulgence of carrying coal to Newcastle. But having put all the coal in the consignment, I had to drive because the toll gates were open. Thank you very much.
Thank you, Ravichander sir. It's just like saying, stand up to be seen, speak loud to be heard, and sit down to be appreciated. Ramkumar sir, your comments.
What a brilliant and literate and forensic treat. We have, the young lawyers must have benefited much on the useful tips, do's and don'ts for lawyers, budding lawyers, not only for budding lawyers, even for senior advocates. It's only when Mr. Vijay opened up by saying, noted the multifaceted person with varied interests and tastes, that we came to know you better. We in Kerala, our spoken English is relatively bad. Your written English may be relatively fair. That is one great handicap of Kerala, not only lawyers, for Kerala people. It was a masterly discourse, very useful for the budding lawyers. Thank you very much.
Thank you, Justice Ramkumar sir. Kondaram sir.
I was only wondering that I didn't have the benefit of listening to Ravichander at the beginning of my career. So that all these techniques, at this point, I'm learning, but still there are so many things which I learned today. I'm sure that because my career as an advocate again started, I'm benefited. And you see, the beauty of Ravichander is, of course, I don't compare him with the Shashi Tharoor. But at the same time, he has the ability of putting the thing in a milder tone, harsher tone, and sometimes much harsher. And also he shows he's a Natasaru Saurabhama. You should also see him on the stage. How he shows his anger, how he despises you or the other side. But that's because I am reminded of once what has been said by one of our very senior civil lawyers, Challa Purnai Garu, one of the doyens of our bar, master in civil law. He said in one of the cases after I finished argument and came out, a little bit of emotional drama took place in the court, wherein the summons were issued to, contempt notice was issued to Director General of Police and others, and collector. He came out and what he said is, I never knew that you are such a big dramatist. I will add to what Ravichander said with respect to the language and other aspects. A lawyer also required to be a dramatist because he has to act sometimes various aspects of human aspects of the individual, so that as he said rightly, a judge is a human being. He gets swayed by emotions. And what matters is that few minutes of your argument rather than how much you know earlier or how much you may know in future. And in fact, I am glad that Ravichander has mentioned, and I will little more elaborate on what has been said by him of autobiographies and biographies. Apart from, I find the reading of earlier generation, not earlier generation, earlier century literature gives a lot of insights about human failings and human miseries. And we see those miseries in a different perspective today, though we may not have. In fact, I am very fond of Charles Dickens, of many of his things, because what I find is that the problems of the society are reflected in that, pictured into that. Likewise, even the Shakespeare, in most of the what we say, we may find in Shakespeare's dramas, in one way or other, many of the sayings. And that also makes us to understand the society. What Ravichander said is the one, in a little more elaboration, the understanding of the society. Only when you understand the society, you will be able to understand the relevance of that particular law. Not if it is only a simple English, if the simple sentences which have been stated or which have been said in the most of our statute as on today, new statute, there is nothing to interpret, honestly. It is interpretation is in relation to the social conditions or to the understanding of your society at large. So in that context, I'm thankful that Ravichander has been kind enough to tell youngsters as well as even for persons like me to read more and more and understand more and more. And what has been said about the pouring of through the digest, we all miss actually. Today, what is happening is because of the computer keying, you may reach a particular case, what has been decided, but you miss so many other aspects of law, which normally in earlier days, when I'm reading for one case, I get to know about so many other things unrelated to this case, but related to other case. We used to write it in our notebooks. Today, we miss that. And eventually, it may become difficult after a particular point of time. You may have the plethora of case law, loads of cases relating to a particular case, but you really miss the new points or new aspects of perspectives which you can project in a given case. In that context, the suggestion made by the senior counsel with respect to reading the textbooks and also the commentaries and also the philosophy, as well as any other, it could be sociology, it could be any other branch. In the end, ultimately would help. Thank you very much, senior. As I said, I am benefited once again. Thank you.
Thank you, Kondaram sir. Ramashan sir.
Really, it's a wonderful treat on a New Year day. In fact, he has touched almost all the areas where how a lawyer should be. See, I remember my senior used to say when he said about don't read the journal, read the judgments, but read the journal. Because my senior used to say whenever the journal comes, I have seen the criticism that has been made on a particular judgment. See, that gives you an idea as to where the judge missed and where it goes wrong. And also give an alternate method which you can see the proposition of law that has been laid down also. So that opportunity will be getting only if you read the journal portion of the law book, the law journals that has been coming up. That most of them are missing that. In fact, I can say because people are going by the head notes and they think that they understood the law. There is also another difficulty that now find from the younger generation, that they are not reading the entire judgment. They only go by the head notes and come and say that there is a law. But they miss this, as Justice Kodanaraman has said. See, if you read a judgment, you are not only preparing for a particular case, you will come across a lot of other ideas which you will have to apply for other cases also. You will get some idea about those things. Those are all the areas where you will have to learn, train yourself as to how to prepare for a case law study. That will give you an input for your improvement in the presentation of the case also. Another thing is clarity of thought is one of the things that is required. Your bombardment language or your literary flavor is not going to help. Maybe sometimes depends upon the judges. You will have to depend upon, you will have to see whether when you are using a language which is more, literally flourished one. Sometimes it may miss the point that you want to raise before the court without knowing whether it has been understood in a proper way by the judge also. That will sometimes may be good or may not be good, but it may also have a lot of things to say on that aspect. That is the thing we'll have to. Another thing is, once you must, as rightly said by the senior counsel, that you must read the attitude of the judge. Once you feel that the judge has captured the point which you want to present, it is always better stop there and go to the next point. That normally the people are not now following because they want to, I can say, split whatever they want to read, whatever they read, and they want to go on repeating the same thing that is being done. That the patience, as you have rightly said, the people are losing the patience of hear a long lectures. Just like sitting in a classroom, and it is the lawyer's job is to make a bad case a good case, to present in a better way that will give a good impression about you. One. Secondly, at the same time, misleading the court for the purpose of gaining a particular aspect or particular case also give a bad reputation for the lawyer. So you must be always true to the court. That is what is required for a lawyer. That will be possible only if you are able to answer the questions that have been put by the judge, because the judge is asking a question for the purpose of clarification. If you think that the judge has made up his mind and get agitated by saying that the judge is going in a particular direction, and if you quarrel with him, ultimately the loser is your client. It is always better when judge poses questions. You must be, as rightly said by Ravichander, that you will have to answer at the same point, at the same time, so that you are clarifying the doubt that has been raised by the judge at that time. So he will not be going by his own notions. He is getting an opportunity to change his notion. And that is the success of a lawyer, when he is able to impress upon the judge that this is a way in which you will have done, this is a position which you want to express, and there is a way in which this will have to be interpreted. And that is what I feel that to be correct. Not that it is always, judge should not follow that, but at the same time, you have to put it in a politely, this is a way in which the people will have to understand. And that will give a lot of respect for a lawyer community in the courtroom also. Because judges will be happy when they are hearing in a polite way, indirectly saying that you are not correct, but at the same time, make the judge to understand what is the correct position also. That always gives a better opportunity to write good judgments also. Really, it's a wonderful tip that has been given by Ravichander, a senior counsel, which the younger generation has to, not only the younger generation, as Justice Kodanaraman has said, you are going, now you have become a lawyer, because sitting in a podium for some time, I'm coming back, then you will have to learn what you are lost at the time when you are in the bench. So that way, it will be helpful for the older generation. After some time, they want to come back to the profession also. Thank you very much.
Thank you, Justice Ravichander sir. Hariprasad sir.
That was an excellent presentation, Senior Counsel Mr. Ravichander. Actually, in fact, he was, I think, as if he has read my mind. He was speaking about the behavior in court, because I remember certain instances where young lawyers, especially from this high-profile law colleges, I'm obliged. See, so many expressions. Normal law college people come and argue the case, whereas the other person, for each sentence, they say, I am obliged. No, I don't know why this servility. I don't understand that. Then there is a what you call type of practice where the lawyers stand up, youngsters stand up, and seek an adjournment in a what you call some sort of a superiority air. They say that maybe another day. That is one way of, maybe when the case is called, maybe another day, as if it is a right to get an adjournment. See, there is a saying by a very senior lawyer of Calicut Bar, Shyam may be knowing, P. Govindan, Nityath Govindan Nair, N. Govindan Nair of Calicut Bar. I am talking you the period before 1940s. In Calicut Bar, he was a doyen of civil bar. He used to tell lawyers that suppose somebody asks, he has a platoon of lawyers, juniors. Somebody asks how much this man is practicing, how long this man is practicing here. Then he used to say 5 years. Oh, so he's able to handle things independently. No. He is now able to seek adjournment. So getting adjournment is an art, according to the old theory. Now it is a matter of right. So these are behaviors probably not appreciated in the court of law, especially when judges of older generation, or rather the earlier generation, presiding over the court. That is one issue. Second thing, as senior counsel pointed out, I am reminded of a saying. A person junior to a senior, a well-known senior, has put in about 10 years of practice, and he wanted to go independent. Senior is very much impressed about this man's capacity, and he was thinking why this man is not going, because he is able to handle things by his own. But anyway, he was not willing to send him out. So this man expressed his willingness to go set up independent practice, and sought permission from the senior to establish an office. Senior willingly, happily said, okay, you have acquired knowledge, you are capable of presenting your case in a good manner. You can do that, you can thrive in your profession, all blessings given. And this junior asked the senior, sir, will you please give me a piece of advice? Then the senior said, no, I will give you a couple of advices instead of one. First advice, even if you lose one case, try to retain the client so that you can file an appeal against the judgment. Second, if you lose the appeal, even if you lose this particular case, try to retain the client so that the next case probably he may interest you. So leave the first case. Try to retain his confidence so that next case he may interest you. Then third, even if you lose the case and the client, don't lose the confidence of the court in you. Don't lose your credibility. No, then the worst scenario, even if you lose that, you lose the brief, client, and the confidence of the court, then don't lose your integrity and self. That is the advice given by the senior. Because my senior used to tell all these anecdotes to me, and I'm benefited by hearing him. So anyway, Mr. Ravichander has almost exhorted to the younger generation to live up to the expectation of the public, live up to the expectation of the great tradition of the lawyers. Wonderfully spoken. It was a very useful evening of the new year. Thank you very much for the good presentation.
Thank you, Hariprasad sir. Now for the not much interaction.
Shyam, yes. It was rightly said that the lawyer should know the psychology of the judge. Absolutely. I have seen one or two very erudite lawyers losing their case for correcting the grammar and English of the judge.
Ramkumar sir, there is a saying that the bar is the most adaptable animal. There is a saying. Because
most docile and
yes, right.
This is Hariprasad. I must tell you, one of Kodanda's successes is, apart from all that he did, he's given the bar two of the best lawyers I can think of, Gunaranjan and Vikram. Two amazing lawyers from whom maybe I've learned many of these. Amazing lawyers.
No, my senior used to say the law without common sense is an ass. Because as Justice Kodandaman said, you must understand, because by reading and also interacting with people, you can understand what is going around you. Unless you know about the reality of life, you may not be able to present the case and also use the law for the purpose of benefit of the society for whom the law itself has been enacted. That is one thing. And also, as rightly said by Hariprasad, the getting an adjournment from a tough judge gives you a practice of being a patient lawyer before a court also.
No, actually, see, you must be aware of a well-quoted saying by Sir C.P. Ramaswamy Iyer, who was a successful lawyer in the Madras High Court and later became the Diwan of Travancore State. And there is a saying by him that a junior lawyer up to 40 shall be seen only with a tennis racket, not with law books. But it is often misquoted and often misunderstood because he was of an immaculate brain for him. Not all 40-year persons have that. So that is actually a misleading advice, probably.
Perfect, sir. So the take-home message would be that you should have a constitution of an ox and the patience of an ass to be in this profession. Dilip, sir.
Good evening, Senior Counsel Ravichander, sir. Good evening, everybody. Happy New Year to all. Thank you, sir, for your erudite and wonderful exposition on the first part of the topic selected for the day. While listening to you, sir, I was examining in verity as to where I stand as a lawyer. And the more I heard, the more I understood that I have not become a lawyer yet. And thank you for making me aware that I have to update a lot about my skills and qualities to become a lawyer, at least. As an average lawyer, thank you. It was a happy New Year gift. The evening well spent. Thank you very much.
We'll go to Shrikant for a minute. Shrikant.
May I take a few minutes, please?
No, he had
Consciously, I used the term 1 minute.
No, he is going by foreign law, foreign courts. Time is fixed.
No, there are. It was a very, very interesting topic and a very relevant topic, considering that the courts are streaming live, and you can see the advocacy of a person quite live, so to speak. So this being said, there's a nifty technique that I use. Since I appear in courts which have, since I cannot travel, I appear in courts which have to be video access as such. There is a problem when you're doing a video, and that's exactly the problem that we have right now, which is we do not quite know who to look at and what to read. And one of the things which gets missed is that when you are looking at a video of a person, you are basically judging the person by the audio that comes out of that particular person and the gestures that come out of that particular person. So I have been, so the way I see that as a nifty technique is when a judge is speaking in a particular manner, I try to imitate the judge. And by imitation, I rather use the expressions which are used by the judge himself or herself. Because when you, imitation is the greatest form of flattery. And when you want the judge to be on your side, you would want to try a bit of imitation in terms of the words and the expressions that they use. It may sound a little off, but if the judge is not pronouncing the word right, you may want to resort to not pronouncing the word right along with them.
Aping the judge also can land you in trouble.
So, for example, if I may get practical over here without hurting anyone's feelings, typically judges who hail from Karnataka use the word judgment in a particular manner. So it comes out in a very emphatic manner, the judgment, which comes in with a lot of tonality in it. So I modulate myself. So it's more of a theater that happens in terms of advocacy. The second thing which I try is that if the judge, as Mr. Ravichander was quite rightly pointing out, do not let the judge bully you. If you have been bullied inadvertently, then it is a brownie point for you, and you can actually score that when the judge is, you are leading evidence against a matter which you do not have a standing as such. So that becomes a brownie point. So you keep that brownie point with you and use it wisely is what I would say. I've scored multiple brownie points like this, like these with many judges and many arbitrators, and it's a nifty technique that you use. So you convert the negative into a positive. So there is some level of I would say soft corner for you. Third thing which I do invariably is if the youngsters are looking at this. Is participate in competitions. There is Jessup, there is Wismoot, there are many moots that are happening. One of the mistakes that we do once we come out and become an arbitrator or a Queen's Counsel or so on and so forth is we go and sit there as a judge for the moot. Do not do that. If you are experienced, go as a counsel in these moots and see what is happening if you are a counsel, and especially when you're being cross-examined and so on and so forth. So I enjoy that. And added on to the layer of advocacy is that when you are having a losing case or a case where you haven't got the judge on your side, I would say put an end to it. Rest the case. If you don't have the judge on your side, just rest the case and move on with hearing the judge out, because the more you let the judge speak, the more the judge is letting out her or his emotions, and the more the emotions come out, the more you are able to gauge what emotions are they positive for you or are they negative for you. So that is something that I use, and in my 15-20 years of experience, it has worked in my favor. One of the things is also for youngsters, which I want to mention, which was already mentioned, which I'm not mentioning anew, is that use as little number of words as possible in a particular sentence, pause, and then make an argument which you want to have an impact. One of the things which I feel youngsters miss out is when the judge asks you, have you read the case? The youngsters immediately shoot back, or most of the youngsters which I've seen immediately shoot back and say that I haven't. That is being truthful. There's a difference between being truthful and being ignorant. So these are two distinguishing things. So have a very clear line between being truthful and showing your ignorance. That would be my add-on to the plethora of or the vast knowledge that was shared by Mr. Ravichander. I look forward to engaging with him in the international courts as well sometime.
10% commission to the platform.
Oh, sure.
Will Kandaram sir, you'll have to unmute.
More than the unmute.
Commission to Vijay.
No, that's what I'm saying, that we'll go straight to Vijay now. Yeah, Vijay.
No, I don't require commissions. Sir, it's always nice to hear Ravichander when he talks about these kind of subjects. And if possible, Shyam, the other day we were discussing with regard to the backlog of cases.
Correct.
He is the guy you can request, where he can really, he has got the art of, putting things very straight.
We will. I mean, that's a wonderful thought. I mean, sir, we can put it across to him straight away. Ravichander, sir, we were thinking on our 275th session, we'll be dealing with the backlogs, the way in which the judgments, etc., are being or not being delivered, the classic conflict between hurried justice is buried justice and delayed justice is denied justice. We were just thinking about a panel discussion, and it's indeed wonderful that Vijay mooted the proposition today. It's really good.
Count me in. Count me in.
Yeah, sure, sir. Done.
That's the beauty of the, unlike Kodandram, where who runs away, Ravichander is always in the front runner.
He tells it in the face, sir.
Yeah.
Thank you. Thank you.
Thank you, Vijay. Now,
one other aspect which has not been told by Vijay is that Ravichander is also a good singer.
Yeah, Carnatic music, he did mention.
He mentioned that he is a Carnatic.
He is a lover of the Carnatic music, but he didn't say that he is a singer also.
Multifaceted.
This I didn't know. This I didn't know. I would have definitely said.
Good, Vijay. Good.
Next time I'll add to it.
So as we come to the end of the 262nd session, may I request K. Vijay Rao sir for the concluding remarks.
Good evening, everybody. Ravichander sir, Senior Counsel, it was nice hearing you. And man is always learning. So there is no age limit to learn and there is no time limit to learning. Having said that, any advice is always welcome. And as it has to be taken in the spirit that it has been mentioned, number one. I mean, I wish everybody a happy new year, but coming from the aviation field is not a good year for us, because 44 years back on this day, we lost an aircraft. One of our the first jumbo jets crashed off the Bombay Sea, and we lost 213 passengers and crew. So, I mean, in the morning, we did have a memorial service for them.
Was it the Kanishka?
No,
Ashoka.
Kanishka was off the Cock Island. That was a terrorist attack. This was a lot of conspiracy theories are there, but we can't put our finger on it. And coming back to the subject of Mr. Ravichander, like you mentioned the Surfacy Act, the authorized officers takes care of that also, where he said, don't rush into giving stay orders. The Honorable Supreme Court held that don't rush into. And with regarding to learning, I mean, 1997, I don't practice, sir. I'm an accidental advocate. I'm party in person on certain cases with error.
Victim advocate.
You can say that, sir. Yes, sir. I am a victim advocate and I am fighting the system. But I happened to see Justice A.P. Shah, 1997. There was this young lady who came to the bar and said, and as you said, sought an adjournment. So A.P. Shah asked her, why do you want the adjournment? He's saying, sir, my senior is not here. So, you forget your senior for 5 minutes. Can you argue this case? So she said, yes, sir, I am. So he said, are you sure? Are you prepared? So he said, yes. She said, yes, I am. He said, then start arguing. Don't waste your time and my time. And she presented her case so beautifully. A.P. Shah was taken aback and he mentioned it in the order that he passed. She says, I didn't expect this from this young lady. I mean, she must have been barely 28 or 29 at that point of time. And the second one was in the year around 2002 when we had Justice Lodha in the Bombay High Court. Like there was this lawyer who was representing a lot of people who had been displaced from their place of living. And every time the lawyer spoke, he would turn around to the audience or his clients and, you know, say, see what I said and all. Wherein Justice Lodha had to stop him and say, look, if you're playing to the galleries, choose another court. If you're arguing on substance, stand before me. So you make up your mind, I'm just giving you 1 minute. And to be very honest, the next case after that was mine, where I was victimized and stuff like that. Sir, I come from the union, so I'm always a victim of management tactics. So And the anger that Justice Lodha showed, I thought I lost my case. And then when our case was called up, my counsel stood up and he said, Your Honor, say, Mr. Shetty, sit down. I have not asked you to talk. So you filed the writ petition, so I've read it. Now let us see what Air India has got to do. So the senior counsel got and said, Your Honor, this man, he's refusing to do his work. So Justice Lodha stopped him and he said, kindly read the charge sheet that you have issued to him. So he said, read it. He said, no, sir. He said, no, read it in open court. So he said, you are charged with performing certain additional duties. He's saying, what kind of a charge sheet is this? You are first saying it is additional duties. You are admitting it is additional. So is he supposed to do that or no as a workman is a fundamental question. Second thing is certain. What is a certain? The certain cannot be an uncertainty. And when Justice Lodha asked my lawyer to sit down, my heart literally sank. Because I said, okay, now I've lost my job. Like he's not going to accept what I'm saying. But it turned in my favor where he told Air India that now every time this man boards the aircraft, you will tell him in writing what job you want from him. You see, because my counsel told him, sir, you're putting him back on the aircraft, but again, they will suspend him next week when he gets back onto the aircraft and saying he didn't do certain other jobs. So it depends on how you put your point across to the judge, how the judge takes it and how the judge puts it on in black and white. Had he not, Justice Lodha had not agreed, he'd have said, I would be in trouble because every time I boarded the aircraft, I'd have a charge sheet thrown at me. So, and like the behavior of the lawyer, as you mentioned, has already been taken care by Lord Denning, which has been enumerated in so many judgments as to how a lawyer should behave in court, where he cannot be the mouthpiece of his client, but needs to present the facts as an officer of the court. So that has been taken care in that. And as you said, as one of the advocate generals told you, that the state is going to file a reply. Take the skeleton from there, put in your body and make your arguments. And I have been fortunate. Like last year, there was a defamation case filed against me by Air India itself, where Air India made Facebook and Twitter a party. And both of them came in my favor and said, look, it's his fundamental right. Every statement that he's made, he's put the documents. So where is the question of you asking us to restrain him from using the platform? So it really takes a lot of patience to learn the nuances of how to go about in court. And today you have come up with an excellent, I would say, even though it was not a PowerPoint presentation, you covered the topic as it should go. And that was very wonderful on your part, sir. And I thank you very much and wish to hear more from you again, sir. And I thank the august body for listening to you, being here on a Sunday evening and a New Year, for the pearls of wisdom that came out, sir. Thank you very much.
Thank you. And sir, what can we say? This is the new year for us. The year, I believe 2022 would give a better treat to all of us. Unlike, we missed out on 2 years. In our calendar, we don't have 2020 and 2021. We have only 2022 now. Let's see what it holds for us. Thank you very much, sir. Thank you, all of you. Justice Hariprasad, sir, Justice Ramkumar, sir, Justice Ramakrishnan, sir, Vijay, Rao, sir, Srikanth, Dilip, sir, all of you. Ravichander, sir, you made the day for us.
Thank you.
First day of 2022.
Thank you so much. Hope to see all of you again.
Definitely, sir. You're part of the family. Till we meet again, sir. Do take care and stay safe.
Bye.
Good day.